Good evening, ladies and gentlemen. Thank you for joining us for our sixth session of Constitutional Revival. It's hard to believe that we are at the sixth session now. Seems like we just started. As you know, this webinar series is being brought to you by your generous contributions. Thank you. We continue to accept donations so we can continue this series for a long time to come. We have Venmo, and we also receive checks at P.O. Box 1837, Shreveport, Louisiana, 71166. The check can be made out to me, but please write Constitutional Revival in the subject line. Again, that's P.O. Box 1837, Shreveport, Louisiana, 71166. I want to tell you that there's a lot going on in this country. We're going to address some of it tonight, a little bit out of order, but thank you for being a part of this. I think you should be proud of yourself for learning these things that you are learning, because this is about what our country does and what it's supposed to be doing. I again thank Joanne Woodard and David Hagar, without whom this series would not have ever been possible. David's company is Beyond Innovative Technologies and Consulting, and he keeps us on the air and online. Anyone wishing to review the material anytime, please go to my YouTube channel, Constitutional Revival with Royal Alexander, and that should keep us on track to finish the series. But we are on Facebook and, of course, on YouTube, Constitutional Revival with Royal Alexander. And you can always email me a question. I answer those whenever they're there. Constitution.royalalexander@gmail.com, constitution.royalalexander@gmail.com. And you can also email me a question. I'm going to go the regular 60 minutes or right at 60 minutes. And then if there are any questions on the screen, I will answer them. Happy to answer them. So welcome back. I want to touch on Ruth Bader Ginsburg for a minute. As you know, she was a longtime Supreme Court justice who passed away 2 days ago. I've gotten a number of questions about this, so I just want to address it out of order. Even though we've already been through the articles, I want to make it relevant to you again. Article 2, Section 2, Clause 2 of the Constitution states that, and I'm putting an impertinent part, the whole paragraph is not relevant for us, but this part is. The president shall nominate, and by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court. It's not just obviously judges of the Supreme Court. He also appoints judges of the federal appellate courts and also of the federal district courts. But for our purposes now regarding Ruth Bader Ginsburg, the president shall nominate, and by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court. So he nominates them, then they have to be confirmed, and as such, they are appointed to the Supreme Court. A simple majority is all that's needed. I know you're already seeing news reports all over the country of, what if we lose this senator or that senator? Murkowski looks like she's wavering. So does Senator Collins of Maine. We never know what Mitt Romney's going to do. God help us. But that's all the political part of it. A simple majority of the Senate is all that's necessary. If it's 50-50, the vice president will break the tie regarding the new justice. If it's less than that, then the judge is simply not confirmed. So all of the debate that we're going to see, and we're going to see a ton of it, we are already seeing a lot of it, all the debate concerning the nomination and the confirmation of a justice in an election year are based upon the decision of the president, who will nominate, and the U.S. Senate to confirm or reject that judicial nominee. And this action can occur whenever there is a vacancy. The rest is politics, honestly. The Biden rule, the McConnell rule, we do it in an election year, we don't do it in an election year. Both parties have been all over the place on that issue, honestly. In politics, whoever thinks they have the advantage uses it. So when people say, oh, it's a matter of principle, to me, what the matter of principle is what the Constitution says. And the Constitution simply says that when there's a vacancy, the president shall nominate, and if given the advice and the consent of the Senate, that nominee is confirmed and becomes a member of the Supreme Court whenever there is a vacancy. So to say these whole timelines things, again, that's all politics. So that's what I wanted to tell you about Ruth Bader Ginsburg. I want to recap what we went through over the First Amendment. This is just going to be a recap, but what we went through about the freedom of speech and what I call core political speech is important enough for me to go back over it again in fairly short order. Keep in mind that in the First Amendment, there are several rights. Freedom of speech is a hugely important one. Of course, by their nature, all constitutional rights are important. But in this day and age, some are come into play more often than others. Free speech is the cornerstone of our democracy. It gives Americans the right to express their opinions without government censorship or control. The First Amendment restricts government. Remember, it restricts Congress. That's the word, but that has been interpreted to mean all government. The First Amendment, the Constitution, restricts government. And it doesn't restrict private actors, which is why I've said things like the NFL. The NFL could, not the NFL, pardon me, the owners of each individual NFL franchise, like Jerry Jones, the owner of the Dallas Cowboys. The Dallas Cowboys are a private corporation, and he as the owner doesn't have to guarantee all these same free speech rights. In fact, he could fire a player if he wanted to for kneeling, standing, doing whatever. Anything that hurts his profits, anytime an employee outside of those areas like race, gender, and several other areas, national origin, that you can't discriminate on the basis of anytime. Other than those areas, for things like speech, the same rights aren't guaranteed when we're talking about a private corporation. So what this means is if the First Amendment is going to mean anything, as I said, it's got to be a right that applies to everyone. So freedom of speech has to apply to even speech we find offensive, despicable, hateful, things like the Nazis who march and speak out, the skinheads. Black Lives Matter has joined that group. Westboro Baptist, the Ku Klux Klan, all of those groups have the right to free speech. So if it's going to mean everyone has free speech, then it's got to mean even the groups we can't stand listening to. Or otherwise, if we don't have free speech for everyone, then we don't really have free speech. So keep that in mind. My focus here, though, is on core political speech. Core political speech is supposed to be robust, sometimes caustic, heated, ugly, uninhibited, so that in the marketplace of ideas, every kind of speech collides, and the best speech, the best ideas rise like the cream to the surface. And those ideas often develop a political consensus behind them and often become law. But every idea gets to be heard. If it's a bad idea, it pretty soon gets forgotten. But if it's a good idea, it keeps getting popped, bang, 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 and eventually rises and becomes an idea that can be broadly supported. We're talking about core political speech. And again, the First Amendment elevates core political speech to really the highest level of all. It elevates it above other forms of individual expression, all other forms of individual expression. Our form of government is based upon the ability to speak, to be heard, to express an idea or a thought. And the court comes down hardest on content-based restrictions. Content-neutral restrictions are an entirely different matter. That place you may be restricting my speech, but you're not targeting me. you're basically restricting all speech evenly. You're just saying at this time and in this place, no one is going to have free speech. That's a content neutral regulation. But if you're stopping me from speaking because I'm pro-life or because I don't like Obamacare and think it's bad policy, bad law, or any other reason like that, then you're going to face strict scrutiny. That regulation restricting me from speaking out about the pro-life issue or my faith or Obamacare or war or anything else, if I'm restricted, that's content-based and it's going to face strict scrutiny. And that's the toughest analysis the court uses. And virtually by choosing to use strict scrutiny, you've sounded the death knell of that regulation. And again, what is strict scrutiny? It means the regulation restricting my speech must be narrowly tailored and it must involve a compelling interest. And most of the time they fall because although the state may have a compelling interest, most of the time you can always draw regulations such that it's more narrowly tailored. You can make it tighter so it doesn't restrict any but the tiniest amount of speech because you're restricting the content of speech. And that is where the greatest force of the Supreme Court scrutiny comes down on it. And it almost always results in that regulation being struck down because it was content-based. Again, content neutral regulations are entirely different. What I want you to remember is that the content-based restriction and the application of strict scrutiny, again, compelling interest with narrowly tailored, being narrowly tailored as possible. And strict scrutiny is even more lethal in those areas that are considered traditional public forums, like streets and sidewalks and parks and other venues that have, way before TV, maybe even way before radio, have always been considered venues where people can go and hold a rally, wave a sign, pass out brochures. Those traditional public forums are the most powerfully protected because traditionally it's been the place that people have been allowed to engage in free speech and the sharing of ideas. So if you're talking about core political speech that's being regulated in a traditional public forum, it's going to get knocked down. It's just going to get knocked down. Now, strict scrutiny also applies to designated public forums. And again, designated public forums are places like state fairgrounds. There's not quite as much free speech because places aren't as traditionally considered public forums as a traditional public forum. They're still designated public forums, but the freedom of speech can still be limited to some extent because they are a designated public forum, but like state fairgrounds, but political speech can still be allowed. It can just be restricted a little bit more because a state fairground is a place it's typically allowed, but still the purpose of that is the state fairgrounds and all of their activity. Even though lots of people are there, speech can still be made, but it doesn't enjoy quite the same freedom as a traditional public forum, like a park, like a town square. But still, designated public forums still do. However, keep this in mind, non-public forums are going to be given a low level of scrutiny if they have regulations limiting speech. In a non-public forum, again, the courts will apply less scrutiny because and allow core political speech to be limited if the regulation, the limitation, the restriction is reasonable and it's not aimed at silencing the individual, the speaker's view. Can't be, again, about the content. Can't be about my views, about my ideas. But if it's not about that and it's in a non-public forum, then as long as the limitation is reasonable and not aimed at my speech, the content, those areas can be more highly regulated. Scrutiny will be less than strict scrutiny in a non-public forum. What are some examples, again, of non-public forums? Toll mailboxes. Really, only the mail is supposed to be in a mailbox. So speech can be restricted there. Military bases. You know, it's a public place, but the purpose of it is for the military. So speech can be restricted there. People test that rule when they want to protest, for example, about a war. Airport terminals. Again, tons of people go in and out of airports, but the purpose of it is for people traveling, flying, coming in and out, but it's still a public forum. But speech can be restricted there as long as it's not content-based. Indoor shopping malls. Lots of people go in and out of malls, but still, usually those malls are private property. So speech can be restricted there. And private commercial and private residential property. Certainly on my own property, I can restrict someone else's speech. So, and also keep this in mind, government may restrict speech by limiting the time, place, and manner of the speech. And a good example of this is, for example, if someone wants to hold a big rally in Betty, Virginia Park. Here in Shreveport, there's a park called Betty, Virginia Park. It's been there a long time. That speech, even though it's core political speech in a traditional public forum, it can be regulated from a standpoint that a permit can be required to go and have that rally. In other words, the city can say, okay, you're free to have your rally. We're not restricting speech. We just want to know when you're going to have it. You know, what do you expect to have going on there? Just so we can maintain law and order and other things. So a permit is an example of a reasonable time and manner restriction. So the city can kind of keep control, but it's not stopping it. It's not prohibiting speech. It's not restricting it. And keep in mind, freedom of speech encompasses not just the verbal word or the written word. It also includes nonverbal communications, like sit-ins. If you want to protest it, you know, at a principal's office on public property, or chancellor's office, or the college president's office, sit-ins are part of speech. Photographs are speech. Films, advertisements, it's all speech. Speech is so broad. It's freedom of expression, and that is so broad. But keep in mind, as I said, the right to free speech is not absolute. It's not absolute. But you essentially have to have something like a clear and present danger of imminent lawless action to stop a speaker. An inflammatory speaker can speak, and only when that speech becomes on the verge of a riot, a clear and present danger of imminent lawless action, can a speaker be stopped. And they're not being restricted for the content as such. They're being restricted because there's about to be a brawl and maybe violence or likely violence. And keep in mind, the way law enforcement handles these situations is if the Klan wants to march, they get held over here and told you can march up and down this street, say these 2 miles, and everyone opposing the Klan stays over there. And the smart thing law enforcement does is just keep them apart. Everybody gets to march, protest. They get to do it in response to one another. But it's when the violence starts that separation is not there and the two groups come together. So even heated, inflammatory, ugly speech is allowed, but law enforcement is allowed to maintain control of it. A breach of the peace, violence, changes all of that. Then speech can be postponed, the groups can be separated. A clear and present danger of imminent lawless action. That's the only time you can an inflammatory political speaker. But there's other areas of speech that enjoy less or no First Amendment protection. And again, I told you last time, defamation. Defamation enjoys less protection. You get to say it, but you can be found liable if what you know you're saying is false. But you get to say it in the meantime. Somebody who's injured gets to sue later for defamation. But the defamatory speech gets to be spoken. So it enjoys less protection because you can be sued over it, but it's still protected speech. But there's several areas that are not protected speech at all. True threats. A true threat is deemed as having no speech value. In other words, I'm going to kill you. The court has decided that has no freedom of value from a standpoint of freedom of expression. I'm going to kill you. So those kind of true threats can be, they enjoy no protection, and a city can pass an ordinance entirely outlawing true threats. Fighting words. Fighting words can also be truly stricken. They get no protection because fighting words and true threats are considered to have no value from a standpoint of expression. What idea is being expressed with a true threat or with fighting words? They're highly inflammatory and very likely to lead to violence. So regulations can ban fighting words. Obscenity. Obscenity also enjoys no First Amendment protection. People always say, well, if that's the case, why is our society drenched in pornography? And the answer to that is because, and it's hard to describe what this would be, but to qualify as obscenity and be prohibited, you have to have the most graphic. It's even past salacious form of sexual deviance, often violent sexual deviance, to rise to the level of obscenity and be prohibited. I don't know what that says about our culture, that a whole lot of pornography that is allowed doesn't rise to the level of obscenity. But that's what the Supreme Court has said. And with the standard of Justice Potter Stewart, I'm sure he wishes he had never written it. He said, well, I can't describe obscenity to you, but I know it when I see it. Well, that's no legal standard to apply. You know it when you see it. Well, what about when someone else sees it? They're going to have a different view, and so they won't know it. I mean, that's no legal standard to use. So child pornography next. So the defamation has less speech protection. True thoughts, fighting words, obscenity, and child pornography has absolutely no protection. You're going to be arrested certainly for filming it, for receiving it, for watching it. It has absolutely no protection. As a matter of speech, child pornography has no protection. Now, one other area that has less than full protection is commercial advertising. Commercial advertising. States have been allowed, because of their police powers of health, safety, and the welfare of their citizens, that every governor, every local elected official, that's where those police powers get exercised. It's not the president's call. It's not the federal government's call. That's what the 10th Amendment and other restrictions, but the 10th Amendment is a great example. Police powers belong to the states, and one of those police powers can be exercised in the area of commercial speech. So commercial speech can be limited. For example, gambling, alcohol, tobacco. Those products, those activities can be restricted and done so from not a standpoint of not offending the First Amendment. Again, because the state is exercising its health, safety, and welfare police powers. It's police powers of health, safety, and welfare. And keep in mind, the government can also restrict other speech regarding a special relationship with the government. I get this question fairly often. Students in a public school don't have the same free speech rights as when they are out on a public sidewalk or when they're away from school. And again, I'm talking about public schools. Students in a public school don't have the same rights, which is why more can be done regarding, for example, requiring them to wear masks during the virus. It's because they don't have the full expression, the full freedom away from the school, in the school, that they do away from the school. And that applies to speech in a public school. Also, public employees. Employers can often look at an email or the private communication of a government computer. If I work at the courthouse, or if I work for the city, if I work for any other public entity, oftentimes my free speech rights are far more limited, because I work for a public entity. So if there's a special relationship with a government entity, for example, in public schools, students, or if I work for the government, as a public employee, my free speech rights are far more restricted. Okay, so keep in mind, again, I know I've been over it. There's a sliding scale of freedom of speech. It's a sliding scale. As I said before, free speech purists don't think we ought to have any regulations or restrictions on anything, including things like child pornography, including things like obscenity, including things like true threats or fighting words. But this is just another quick run through. Commercial advertising and defamation are still free speech, but they are more restricted. They have less freedom of speech if it's commercial advertising or defamation, for those reasons that I explained. But things like speech that involves true threats or fighting words or obscenity or child pornography have no protection in the area of freedom of speech. And the most important thing, again, is protection of core political speech. It is those issues that directly affect our government, our lives, the laws we live under, the culture we live in, those issues that are given the greatest protection by the Supreme Court in the area of the First Amendment, freedom of speech. And again, to limit core political speech, particularly in a traditional forum, you have to have a clear and present danger of imminent lawless action. And then all you're doing is delaying or postponing the speech. Just because there's about to be violence, we're stopping the speaker, but as soon as we get you all separated, the speaker can start speaking again. It cannot be content-based. It cannot be content-based because we don't want to stifle ideas. We cannot have a free society if people cannot truly express their ideas. And yes, this is a huge country we live in. Some of those ideas are going to be despicable to us, hateful, racist, sexist, ugly, vile, reprehensible. If we're going to say we have freedom of speech in this country, even that speech has to be protected. In fact, in particular, that obnoxious, vile speech has to be protected. You easily get a consensus in this country about, well, we're in a crazy time. Let's say that in the past, the flag, mom, and apple pie, any form of speech addressing the flag, American flag, mom, and apple pie, any speech regarding that would be supported by a large majority of America before this crazy year, let's just say before 2020. And so it's easy to protect speech like the flag and mom and apple pie. Even though I mentioned the flag can be burned, but whatever is all American, whatever we think decency is, whatever would garner a majority of support, that speech gets to be protected. But it's easy to support that kind of speech because that's what we believe in. If we're really going to have freedom of speech, we also have to protect the speech that is vile and offensive, like the Klan, like the Nazis, like the skinheads, like those Westboro Baptist people, like Black Lives Matter has become. Not what it was right at the time of George Floyd's death, when I do think the nation was behind reforms of police for excessive use of force. That has all changed now. In fact, it changed months ago. That speech that we find most offensive has to also be protected. It has to, or we don't have freedom of speech. So just know that's the greatest protection, but it's still not absolute. Virtually no speech is absolute, but core political speech is the closest thing to absolute. So that is, I'm sure there are other things I would have wanted to tell you. And again, the difference was traditional public forums, designated public forums, and non-public forums. Depending on where you are, that also affects it. So I just want you to know, when you hear about speech being restricted, and keep in mind what's going on, and I'm about to move over to free exercise of religion, but keep in mind what's going on. Social media and Twitter, Facebook, all of it, the national news media have become so hostile to what I consider traditional or conservative speech that they're trying to cancel it, to shout it down, to silence it. And now more than ever, it is important that we demand our free speech rights. We can't back up and be intimidated. People died to give us these rights to speak out. And I will be damned if we are going to back up and relinquish them. People were died and grievously wounded to protect these rights. Again, what I quoted last time. It's amazing, a French philosopher would have defined it so well, Voltaire. I may disagree with what you say, but I will defend with my life your right to say it. That is as good a characterization as our First Amendment freedom of speech as I've ever seen. I may disagree wholeheartedly, completely, vigorously with what you say, but I will defend with my life your right to say. So that's where we are in freedom of speech. Now, other parts, as you know, of the First Amendment include free exercise of religion. That's why the First Amendment is so powerful, but of course they're all powerful. They're all powerful. We don't use some of them as much now, but again, our framers were brilliant when they put all this together in my view. Free exercise of religion. I know you know what this means, but I want us to get a better grasp of it. I want us to have a very good grasp of it. Free exercise of religion. What does that mean? The First Amendment's free exercise clause allows a person to hold whatever religious beliefs he or she wants to hold and to exercise that belief by attending religious services, by praying in public or in private, proselytizing, speaking out, writing, wearing religious clothing such as yarmulkes or headscarves. Those are all examples of the free exercise of religion. And often, even in a public, I mentioned schools a minute ago and government employees. Oftentimes, even in those situations, an accommodation is made to allow for a scarf or a yarmulke. And those debates are very heated, but I'm just telling you the reason they're heated is because the free exercise of religion is a powerful right, and it should be. And I get worried sometimes that it gets ignored. But freedom of expression allows all those things, but you're also free to absolutely not exercise any religion at all. You're free to believe, and you're equally free not to believe. And as I mentioned before, there are no religious litmus tests. In Article 6, we went over that. The end of Article 6. There are no religious litmus tests to be eligible for public office. You don't have to be a Catholic or a Jew. You don't have to be Muslim. You don't have to believe one thing at all in the way of a professed faith to be eligible for public office. That's what the framers put in place, and it's so rare to have that freedom. We're freedom to believe, we're free to worship and to believe whatever we want or nothing at all, and it cannot be held against us. It cannot. Again, private society, people can say he doesn't go to church, he's a terrible person. That's not what I'm talking about. I'm talking about government. Government cannot restrict our free exercise of religion. That's why, and I know I'm digressing, but when these things come to me, I want to share them. That situation that's now been to the Supreme Court twice about that baker in Oregon, Masterpiece Bakery. If you see the cakes that man makes, if I were representing him, they're saying, and they did it on purpose, because there's lots of bakers in Oregon that will be happy to bake a cake for a gay couple. They went to the one bakery they knew the man was going to say, I'm not making it, because they wanted to be turned away so they could sue him and have that case go to the Supreme Court. All of this is very orchestrated. But that man, Jack, I forgot his last name, makes those beautiful cakes. I mean, to me, those cakes, not only are they delicious, they're works of art, those cakes. That's why he calls it masterpiece cakes. To me, those cakes he makes are art. They're like a painting. and it requires great expression on his part. I think it's part of freedom of expression, his personal right of freedom of expression to make the cakes that he wants. Of course, Oregon is a liberal state and wants to shut him down. So they're going to say, well, yeah, maybe that is your free expression in making the way you, like a painter, Michelangelo, the way he painted the Sistine Chapel, the way Jack, my friend Jack, whatever his name is, makes those masterpiece cakes in Oregon. No less a form of expression, it's art. But Oregon's going to say, yeah, that may be fine, your expression, but you don't get to discriminate and open a business under the laws of Oregon. So either you don't stay in business or you make cakes for everyone who comes in your door. I think that transgresses his free exercise of religion to not want to bake a cake for a gay wedding. But they're doing it to him on purpose because there's 100 bakeries in Portland or anywhere else in Oregon that would be happy to make a gay wedding cake. They just went to the one place who wouldn't to spark this case. So that's a classic example of the fight. I would be arguing it's his artistic expression. It's his freedom of artistic expression in making those cases. But the state of Oregon will argue, no, they're discriminating against people who are gay. And that's where that collision is. So I just wanted to say that. That's free exercise. Now, the seminal case in the area of free exercise of religion, there have been others, but still the landmark case continues to be Employment Division of Oregon versus Smith. Yet another Oregon case. But this case, the facts are different. Now, I want you to understand what I'm saying because a lot of people disagree with this. And Justice Scalia wrote the opinion. So that's what's interesting about it. I want to describe a free exercise of religion, this landmark case from Oregon. What it involved was the smoking, the ingesting of the drug peyote. Peyote is, what I understand it, a form of an hallucinogen. It is a drug. It is listed on the schedule of narcotics in the state of Oregon. It is listed in the schedule of illegal narcotics in the state of Oregon. Well, a certain Indian sect, Native American Indian sect, uses peyote as a form of its worship. And I forgot what maybe the Nez Perce Indians. But for years, peyote has been a form, legitimately, for a long time, a form of worship for this sect of Indians. And one of them was arrested for using peyote, and because it was an illegal drug, he was denied workers' compensation benefits. And so that's how the case got to the U.S. Supreme Court. But this is the distinction I want you to understand. Peyote is just one of hundreds of drugs listed as illegal prohibited substances in the state of Oregon. Also on the list prohibited along with peyote are cocaine and angel dust and heroin and PCP. Of course, that is angel dust. And on and on and on and on. It lists hundreds of drugs that are considered illegal in much of the United States, but certainly for my purposes, for these purposes, in the state of Oregon. Peyote is just one of the many drugs. And that distinction is about to be important. It's one of hundreds of drugs that's illegal and prohibited in the state of Oregon. So this case, this Indian worshiper was ingested peyote. The hallucinogen, I assume, is part of their worship, part of the way that they engage in whatever form of meditation or however you would describe it, prayer. He was arrested for the use of an illegal drug, peyote, even though that tribe of Indians, that sect, had used it for many generations. And I want you to understand, this is the one rule in that lengthy case that it all comes down to. A valid and neutral law, and every word is going to matter. A valid and neutral law of general applicability that only incidentally burdens religion is constitutional. Now listen, I'm going to say it again. Every word matters. If somebody said, what is, usually you have in the area of constitutional law, it's hard to get it down to one sentence and say, that's the rule, that's the law from this case. It's usually just considered the holding in that case is, but this is the rule in this case. And keep in mind, free exercise of religion, peyote. Here's Justice Scalia writing the opinion. A valid and neutral law of general applicability. So it's valid and it's neutral. That's important. This drug law in Oregon, it's valid. You can prohibit drugs. It's neutral. It's prohibiting hundreds of drugs. It's generally applicable because it applies to the whole population of Oregon and not just this sect of Indians. That only incidentally burdens religion. See, no one's targeting this group of Indians. No one's even targeting their form of religion. Peyote just happens to be a drug they use. That's only incidental to this regulation. The state has the right to make drugs illegal. It only incidentally is burdening these Indians' free exercise of religion. No one's targeting them, and there are cases where you can tell from the ordinance one group of people exercising, like it was a case in Florida. You can no longer cut the heads off of chickens. Well, the Hiawatha Indians in Florida, that's how they worship. And so the local ordinance, people were getting sick of seeing chickens with their heads cut off because that's how they worshiped. The court said, no, this is unconstitutional because you're the only group that this ordinance in Florida reaches is this group of Indians who cut off the heads of chickens, the Hiawatha Indians. That's targeting, but that's not what we have here in Oregon. Keep in mind, a valid and neutral law of general applicability that applies to the whole state of Oregon, that only incidentally, they're not targeting the Indians who use peyote. It's only incidental that burden on them. Only incidentally burdens religion is constitutional. And here was the analysis, Justice Scalia's analysis. The court examined whether the free exercise clause of the First Amendment allowed the state of Oregon to deny unemployment benefits to someone fired from their job for smoking peyote as part of a religious ceremony. Again, those Indians use it in their religious worship. Peyote is a controlled substance, as I mentioned, under Oregon law, and its possession is a criminal offense. That is constitutional. It's constitutional to criminalize drugs because, and he goes on to say, because the law is valid and neutral and not aimed at the peyote and this particular form of worship by this sect of Indians, it applies to everyone in Oregon. And it's not specifically aimed at a physical act engaged in for a religious reason. Again, that's hugely important and is what distinguishes it from the Indian case in Florida. This is Scalia. In its 6-3 decision, the court held that because the ingestion of peyote was prohibited under Oregon law, and because that prohibition is constitutional, Oregon did not violate, this Indian who was arrested for using peyote, did not violate the free exercise clause in denying persons unemployment compensation when they were dismissed for having used peyote, which is illegal. They were fired for it. Then they applied for workers' compensation. And Justice Scalia, writing for a 6-3 majority, said, you weren't targeted. No one said, we want this sect of Indians. We can't stand your religion. We're targeting you. We're punishing you because we don't like the way you worship. And we're using peyote as a way to do it. The Supreme Court, 6-3, Scalia said, nope. Oregon can criminalize drugs. And again, so that makes it a valid and it's a neutral law because it's not just peyote. Again, there's hundreds of drugs on the Oregon state law list of controlled dangerous substances. Hundreds. So it's a valid and neutral law of general applicability, because it applies to everyone in Oregon, not just these Indians. That only incidentally burdens religion. No one's targeting the sect. We're saying nobody can use peyote, even if you're not an Indian. Don't be walking down Main Street with peyote on you. You may not believe in God at all. You still can't have peyote on you. You can't use peyote. Doesn't have anything to do with just these Indians. They're burdened also, but they're not singled out. Only incidentally burdens religion. Does not offend their free exercise clause. So that's a big deal. You know, that's a big deal. A lot of people didn't like this decision. They said if it has anything to do with especially a lengthy period of worship, and this sect of Indians had been worshiping that way for a long time, even though, notwithstanding. So they said, oh no, it should get strict scrutiny. When you, and we know this, we've talked about strict scrutiny. It pertains to speech, and there are lots of other areas. If you're going to restrict a fundamental right, like the free exercise of religion, then you have to have, the state has to have a compelling reason. Let's say Oregon has a compelling reason. We don't want a bunch of people on drugs, stoned in our state. It ruins people's lives. Our police powers, health, safety, and welfare allow us to restrict drugs. So we have the power to do it. So we have a compelling interest, but is it the least narrowly tailored it could be? Some people say it wasn't. Some people say it could be more narrowly tailored, that Oregon law, if you just exempted peyote. Just grant an accommodation or an exemption for the use of peyote by that group of Indians in their worship. But then other people are going to argue, well, what about, I use cocaine? You know, somebody would argue. Not me, please understand. Somebody would make this argument. Well, my client, he worships, you know, some other kind of Zen religion, but he believes fully that I get more in touch with my Zen and the spirits when I snort cocaine. My client wants to be exempted too. So you see where this would go. Everybody who wants to use an illegal drug would start saying, oh no, it's part of my free exercise of religion. So you have to decide whether a particular religion is being targeted. But if it's only incidentally burdening religion, and it's a power the state clearly has, a valid and neutral law that generally applies, then it doesn't impinge on free exercise of religion. So, and keep in mind, we know this, for the free exercise of religion issue came up all during the virus. I know you know that. Why can the big box stores be open where people wear masks and go in there? Why can abortion clinics stay open? Why do liquor stores get to stay open, but not small businesses? What about small businesses? What about churches? What about churches? People can just as soon separate in a church and wear a mask. And by the way, if masks work, then why do we have to social distance at all? No one ever explained that to me. But if you can social distance and wear a mask in a big box store, why can't you do it at church? Which is why I have written several things about that. And although my position has not prevailed in federal district court in Louisiana, I promise you that it's a weak argument. But what the judge says, and those federal judges are saying, is the state, the law gives a state leader, a governor, great power to provide for the health, safety, and welfare of its people. Okay, that's a compelling interest. But is it narrowly tailored? Why do just bars not get allowed? Why are they shut down? Why are bars flatly shut down? But you see these massive protests. These Black Lives Matter people aren't wearing masks. They're all packed in there together like sardines. What about that? Oh no, that's okay. Because, you know, we're raising hell about racial issues or whatever. So that's okay. You know, but not if you want to go to church. That's what makes people mad. It's so inconsistent. It's not narrowly tailored. Sure, Louisiana has a compelling interest in not allowing this virus to spread, but make it as narrowly tailored as possible. Don't carve out churches and not allow people to go to church if you're going to let them go on a march, a protest, usually a riot. You see the inconsistency. So that's why the free exercise of religion, people have been so heated about. Because I tell people, It's actually right there in the First Amendment. It's written out. It hadn't been one of those rights the Supreme Court had to create from what they call penumbras and emanations, implied. This one didn't imply. It's right there in the First Amendment. Free exercise of religion shall not be abridged, shall not be infringed. So that's free exercise of religion. I know I only have, okay, I have 10 minutes. That's free exercise of religion. Now I want to move over to the Establishment Clause. And let's, maybe I can finish, we'll get as close as we can. The Establishment Clause. What the framers of our Constitution were most fearful of, historically, was a state religion, like the Anglican Church, that was the state religion in England, in Great Britain, which is why in the Declaration of Independence, Thomas Jefferson said, we are separating from you, Great Britain, because you have been an abuser, a usurper, you have treated us terribly. But the Establishment Clause, it's been taken in the wall of separation between church and state. This is one of those things I want you to remember. If anyone ever says, what about the wall of separation between church and state? You tell them, I'll buy you a steak dinner if you show me where in the Constitution the wall of separation of church and state is. It makes people so mad when you ask them that question, because they're assuming from Supreme Court jurisprudence this whole concept of the separation of church and state. But it's not in the Constitution, so bet them a steak dinner. Just say, you know what, you go head on. I'll buy you a steak dinner if you just show me where those words are in the Constitution, where the separation of church and state is there in the Constitution. Because free exercise of religion is right in there. And prohibiting the establishment of religion is right in there. So show me where separation of church and state is right in there, because it's not. All right, separation of church and state, keep that in mind. That phrase came about in a letter from Thomas Jefferson to the Danbury Baptist. That phrase has been, in my view, as misconstrued purposely, as perverted, as twisted as any constitutional expression I've ever seen. And it's not in the Constitution, but it's always cited by people, most often, who are hostile to religion. We're way past in this country not having a state religion. That's what the framers feared, but they never intended for the Establishment Clause, historically or legally, from a constitutional perspective, the Establishment Clause to be used to drive religion out of the marketplace. That is so false. That is so contrary to history and their words. They just didn't want a state religion. Beyond that, they wanted free, uninhibited expression of religion, free exercise of religion, or no religion at all. It's a freedom of conscience is what they were thinking. You're free to worship in any way at all or not at all. They wanted the free exercise to be as broad and powerful a right as possible. They never would have dreamed the Establishment Clause would be used to smash down and undermine free exercise of religion. But our country, I'll say the elites in this country, media, Hollywood, are so hostile to religion, so hostile to Christianity, so hostile to the notion of any sort of a traditional belief or a traditional value. The very values this country was founded on. And I sure don't have time in 10 minutes to tell you about those. But this hostility to religion is why it's so easy to say, can't say anything. All it said, and here we go. The Establishment Clause prohibits the creation of a national religion, which they faced in England, the framers, and also prohibits the U.S. government from favoring one religion over another or excessively entangling itself with religious groups or with religious issues. That's all reasonable. The government shouldn't entangle itself, and it shouldn't favor one religion and disfavor another, of course. But that's all they meant. That's it. That's all the framers intended. And it was Jefferson, as I mentioned, who introduced this concept of church and state. And he'd be the first one to say, it's not in the Constitution. But keep in mind, as we know, the 14th Amendment applies to the states. The Establishment Clause applies to the state, and it's been incorporated through the 14th Amendment. And so it does apply not just to the federal government, the Congress, but also to the states. But it's often difficult when you're talking about individual rights and you're talking about the Establishment Clause. The Supreme Court in this area focuses on 3 issues, 5 minutes, 3 issues. Can the U.S. government give financial assistance? This is what the Establishment Clause really comes down to. Can the U.S. government give financial assistance to religious groups? That's the first thing, because they are taxpayer dollars. Can they also go to religious groups? And I'm going to explain that in a minute, hopefully, or certainly I'm going to finish it next time. First thing, can financial assistance go to religious groups? 2, is state-sanctioned prayer in public schools acceptable? The answer to that is no, generally, except student-led prayer is absolutely allowed. And I'm going fast, so I'm painting with a little broader brush, but in public schools, the principal is not supposed to be the one that's leading the prayer, but the students can, student-led prayer. So that's what they mean by, is it state sanctioned? Are religious displays in government-affiliated places acceptable? Like walking into the Caddo Courthouse. Could you have a Christmas tree there? Could you have a cross there? The answer to that is yes, as the court has said, as long as there are other things there also. As long as you have, other, in this case, Christmas kinds of decorations. You can't target and say, oh no Christmas tree, no cross. You can't target, expressions like keep Christ in Christmas alone. But if they're in a group, then they're allowable. So what has been used, and if I go a few minutes over, I'm just going to, is the Lemon Test. The way the court decides these issues, whether or not federal funds can be used for financial assistance to religious groups, whether or not state-sanctioned prayer in public schools is allowed, and whether religious displays in government-affiliated spaces is acceptable. The way those questions get answered by the U.S. Supreme Court in the area of the Establishment Clause is by what's called the Lemon Test, L-E-M-O-N, Lemon v. Kurtzman, K-U-R-T-Z-M-A-N. It's a 1971 case, Lemon v. Kurtzman. See, you are doing constitutional law tonight. I want you to know. This is straight up constitutional law. Lemon v. Kurtzman. Look at what it says. That test, and the court always bashes the Lemon Test, but they never move away from it, because really it would be hard to think of a better bright line test if you're the Supreme Court and you have to answer their question, is this establishment of religion? Because suits get filed across this country. Oh, that's religious activity on public grounds or public money, can't do it. Those kind of suits get filed daily in America. But the Lemon Test, what is it? To determine, it's a 3-part test for determining whether or not a law violates the Establishment Clause. What's the first? To decide whether a governmental action violates the Establishment Clause of the U.S. Constitution concerning religion. The first prong is, number 1, does the action have a secular or legislative purpose? Because if it does, it's much more likely it's going to be allowed. Number 1, does it have a secular or legislative purpose? That's the first question in the Lemon Test to decide whether something violates the establishment of religion. Number 1, does it have a secular or legislative purpose? Number 2, does it have the primary effect of either advancing or inhibiting religion? Everyone always thinks about advancing religion, but you also cannot inhibit religion. You see, it's trying to stay right in the middle. That's what we're doing. So number 1, is there a secular or legislative purpose? 2, does whatever is going on that's being challenged as violating the Establishment Clause, does it have the primary effect? And primary is important, because if it just has a little effect, it may be able to stand. But it's the primary effect of that display that's being challenged. Does it have the primary effect of either advancing or inhibiting religion? And the third prong of the Lemon Test is that whatever that is, whatever the action is that's being challenged as a violation of the Establishment Clause, must not excessively entangle government in religion. Okay? Must not excessively entangle government in religion. Those three prongs, even though it always says we got to find something better, they keep using the lemon test. The three prongs. One, does what we're examining right now that's being challenged as violating the Establishment Clause, number one, does it have a secular or legislative purpose? Because if it does, it may be okay. Number two, does it have the primary effect of either advancing or inhibiting religion? Because it's not supposed to be doing either. But in the way that you can't advance it, you also cannot inhibit it. So they got to dance right on a thin line. And thirdly, whatever this expression, statue, yarmulke, religious symbol, whatever it is, does it result in an excessive government entanglement with religion? That is the lemon test. That is, but let me tell you, what time is it? 7:01. Look, I hope y'all stay just maybe a couple more minutes. Let me just tell you why there's no hostility in the Establishment Clause and the free exercise of religion. None of the framers, none of them believed that a public role for religion was an evil in itself. None of them believe that. I don't care what these people say today. They're either lying or they're stupid. I mean, I'm sorry for saying that. They're ignorant. They're either lying or they're ignorant. The framers of our Constitution believed that a public role for religion was not an evil in itself. You could go too far, of course, like having a state religion. But alone, my God, they thought religion was an indispensable support for maintaining civic life and the virtue of a nation. It's insane to say otherwise. They said, this is one phrase, nor did most of the founding generation believe that government ought to be untouched by religion. They didn't think government should be untouched by religion. On the contrary, or ought not to take an interest in furthering the people's connection to religion. They thought government could take an interest in furthering people's connection to religion. In fact, they thought it was a great idea. Here's in his first inaugural address. The Northwest Ordinance of 1787. When it enacted the Northwest Ordinance, an education initiative, Congress stated, quote, religion, morality, and knowledge, being necessary to good government and the happiness of mankind, schools and the means of education shall forever be encouraged. Religion, morality, and knowledge. They got to always be encouraged, or you're not going to have a strong nation. And George Washington, I think he's pretty good authority. Very first president. You think he sat through the Constitutional Convention all 5 months in that very hot room in Philadelphia. Very uncomfortable, but they had to keep the windows and doors closed because they weren't supposed to be in there writing a new Constitution. They were supposed to be in there revising the Articles of Confederation. Anyway, George Washington sat through all of this. He was the general during the Revolutionary War. This is what he said in his first inaugural address. His first official act, he said, I ask, quote, with fervent supplications to that almighty being who rules over the universe, that he might bless this new government. Does that sound like someone he's the new president? Does that sound like someone who's shying away from God or the need for religion? His first official act, he makes fervent. You know what that means? Vigorous, strong, fervent supplications to the almighty being who rules over the universe, that he might bless this new government. And this is the last thing I'm going to say tonight. Quote, in tendering, this is Washington still, first inaugural address, in tendering this homage to the great author, that's how he refers to God, the great author of every public and private good, I assure myself that it expresses your sentiments not less than my own, that he's appealing to the great author of every act, public or private, the great author, nor those of my fellow citizens at large less than either. No people can be bound to acknowledge and adore the invisible hand. Again, who's the invisible hand? God Almighty, which conducts the affairs of men, people, more than of those of the United States. He's like saying, I'm going to acknowledge the great author of every act, public and private. That is how I feel, and I'm certain it's how you feel, my new people, for whom I will serve as president. And he says, about all of us in this new country, no people, meaning this new American country, can be bound. No people can be bound to acknowledge and endure the invisible hand which conducts the affairs of men, of people, more than us, the new people of the U.S. So I'm going to stop there. But when people tell me, oh no, they didn't want any involvement with religion, it's stupid, you know. But for my good upbringing, I would have a hard time not telling them that that's completely wrong. But anyway, I will see you next time. If there are any questions, I'm going to look on the tote board over here and see if there are any questions. Thanks. I know I'm a little past, but we had to go on and dig into establishment so we can stay on course. Let me see some, let's check over here for some questions. All right, here we go. Mr. Alexander, people always tell me, this is Atlanta. Thank you for joining us from Atlanta. People always tell me that freedom of religion is not nearly as broad as the reach of the Establishment Clause. In other words, what they're saying is the two collide. So how broad is free exercise of religion, and when does it collide? When does this huge freedom of free exercise of religion collide with the Establishment Clause, which says that, oh no, we're not going to have a state religion? And my answer is a great question, because the two are always in tension in a way. You can have free exercise of religion, but it can't be so free, meaning the government gets involved, that we now have a state religion, because that would be the Establishment Clause. But all I'm telling you is, conceptually, the way I look at it, free exercise of religion is a huge circle on the diagram, and the Establishment Clause is a much smaller circle. Again, what I've just read you from the Northwest Ordinance and the language from the first inaugural address of George Washington, who saw all of it. He led the army that won the war. Then he sat through the whole convention and heard them debate every bit of this, in that constitutional convention, and then became the first president. What he just said about the great author of life, the invisible hand, he's not only seeking the blessings of God on our new country, but he's saying we wouldn't even be here but for all those blessings from the great author of every act, the blessing of every act, public and private. So to answer your question, conceptually, I see the free exercise of religion as being far broader of a conceptual matter in our constitutional law. And I see the Establishment Clause circle as being much, much smaller. Here's another one. This is about freedom of speech. Mr. Alexander, when does, it's just hard to say. When do the areas of speech like true threats and fighting words, when do they ever have value as a matter of free speech? And when they're not just fighting words that can be immediately prohibited? And that's a great question. So let me answer it like this. True threats and fighting words, they are given no protection by the First Amendment. But what if what I'm saying as a speaker, say I'm standing on some toy, some swing set, some a park bench at Betty Virginia Park, standing on there speaking, and I'm saying some very inflammatory things that are so inflammatory that people are about to start attacking other people. There may be a crowd there supporting me, but another crowd gathers on the other side of the park who can't stand what I'm saying, who hate it. When does the clear and present danger, when does imminent lawless action take place? Well, I get to say very inflammatory things. I do. If it's in any way related to any issue, any occurrence, any activity in our local, state, or federal world, our whole society, I get to stand there and say it, even if it's ugly, you know. And a lot of speech is very ugly. A lot of it is very racist. A lot of it is very hateful. When does, and that's really a great question, when does my right to speak these words that are about to cause a fight, how is that distinguished from fighting words and true threats, which get no free speech protection, which in the eyes of the US Supreme Court have no value as a matter of speech? What's the difference in that and me standing on a park bench saying, and I can't stand this president, and we need to run him out of office, and he's terrible, and he's, you know, he hates white people, or he hates black people, or more and more inflammatory. Those are issues of the day, so my speech is protected. But the question this individual is asking about how far do I get to go before they can say, oh no, now we're at fighting words, now we're at a true threat. We got to stop you, Mr. Alexander. We're about to have imminent lawless action, meaning we're about to have violence. But those are really good questions, and I hope we have answered them. Please email me again. I know I said it at the beginning because I have so many email addresses, I always forget which one. Constitution.royalalexander@gmail.com. Constitution.royalalexander@gmail.com. Please email me if you have a question. Thanks for joining us tonight. And we are going to go on and finish the First Amendment next time and go into the Second. And what is the Second Amendment? The right to keep and bear arms shall not be infringed. Shall not be infringed. We're going to take that apart and we're going to keep doing it. So please stay with me. Please tell other people about the videos we're making. So just so what I'm doing can be spread, because I just want people to know their rights. All right, guys. Have a good night, and I'll see you in 2 weeks.